Introduce yourself, give us your testimony.
Craig Eiland on behalf of Texas Trial Lawyers Association. Thank you, Mr. Chairman. I'm going to go brief. I'm going to go fast because I have a lot to say in a very short time. I want to talk about a couple of general things and then talk about specific portions of the bill beginning on page 17. First, this bill, its whole purpose is to cap damages in jury trials. It says so by the proponents in the flyers that they sent out last week about the bill. That's its purpose. We knew this at Texas Trial Lawyers, so we conducted a survey in January. We hired a Republican pollster to poll Republican voters and 3R primary voters. And we had focus groups in Dallas, Houston, and Tyler. And the result of that poll, which I think all of your offices have received, but the result of that poll was overwhelmingly that Republican primary voters do not want the government to cap damages in civil trials. They trust the juries more than they trust the government. The second thing that we learned is what we already knew, and that is from the focus group, and that is Trump voters are very good jurors because they don't trust the government and they know the value of life. They know the value of life without pain. They know the value of life without suffering. They know the value of life without impairment and disfigurement. So now let's talk about specifically on the bill on page 17. We hit on it this morning, but it says the government, the legislature, the government is going to punish you if in a civil case if you do not use your health insurance for your treatment. Think about that. The government's telling you that you have to use your health insurance. But you may have a very good reason. Maybe you have a lifetime cap on some of your treatment under your policy. Maybe you have a MedShare Christian health insurance plan, and you don't want to have that group of people suffer and pay big bills over the next couple of years while you litigate this case. Maybe your health insurance doesn't pay the doctor that you want to go to, so you got to go somewhere else. There are valid reasons a person doesn't want to use their health insurance in cases like this, and the government shouldn't tell them that they have to. Next, what is pretty remarkable is you have to give access to your entire medical history from the facilities that are involved in your medical treatment on the case. I went to UTM, living in Galveston, I went to UTMB for all of my health care for the last 30 years, including when Dr. Schwartner was there training. All of my medical records there. If I'm in Galveston, I'm walking across the street and get hit by a car like my friend Danielle did on Friday, and I go to UTMB, and then I bring a lawsuit because of that car wreck, you know what comes into evidence? Everything that I've ever been treated for at UTMB in the last 30 years, including my vasectomy in 2000. Now, what does that have to do with the car wreck where I have head and back injuries? Think about it from a woman's perspective. Same thing if you have all your health and treatment at Scott and White or in some other healthcare system like Memorial Hermann, and you had vaginal personal issues, you had terrible menopause and have all kind of things in your medical records that not even your husband knows, and then you have a back injury or a car wreck, all of that evidence is going to come in, whether it's relevant or not. This bill gets rid of Texas Rule of Evidence 401, 402, and 403 because hysterectomies are not relevant in most personal injury cases, but it's coming into evidence. 30 years of medical records coming into evidence if you go to that same healthcare provider. And since we all have big healthcare systems, all of your records are there, and they're all coming into evidence whether they're relevant or not. We are going to tie, so the bill says that the workers' comp system is going to be evidence and admitted into evidence to show what is reasonable and necessary for treatment. Think about that. Not public data, but government data from the workers' compensation system is going to determine what your treatment plan, whether it's reasonable and necessary. And I don't think that that's appropriate. Finally, this bill tries to, it codifies the law that says we can't, when we're talking about non-economic damages, that we can't talk about the value of life. That's what we know that jurors, and especially like I said earlier, Trump jurors know the value of life. This bill says you cannot talk about the value of life whenever you're talking about non-economic damages. I have a few other things to say, but maybe we'll get to them.
And we're going to skip over to Ms. Aker.